It was attributed to Chesapeake, I think, and they disavowed it, and then some of the brokers that were working for Chesapeake, and then they disavowed it. I think ultimately they did prove that that was a hoax, and that it was sent out there by an anti-oil and gas group, whoever it was. I think they did have some evidence to that fact. But I've got a copy of that. If anybody would like it, you can email me, and I'd be glad to show you. It makes for some interesting reading because, again, anybody that would instruct you to work that way would never reduce that to writing and put it out there, I don't think. It was pretty humorous, and again, I think it was proved to be a hoax. Nonetheless, that led to a pretty much of a furor up there among the landowners and the legal industry. A lot of landowners were claiming that they were being taken advantage of by these unscrupulous landmen who were coming out and promising the world much worse grievances than the guy going out and putting a stake in the ground saying this is where we're going to put your will. There was the main instigator in the legislature up there was State Representative Mark Oakey from Carrollton in Carroll County, which is the center of where a lot of this Utica development's going on. And he's introduced several different bills over the last 2 or 3 years up there. But the one in House Bill 493 in 2012 called the Truth in Leasing Act ultimately failed in committee and never got out of the floor, but it was mainly due to some strong lobbying efforts on the AAPL and the local associations up there. But among some of its provisions in the Truth in Leasing Act, it was a requirement that landmen were to register with the state and provide landowner with certain disclosure forms when leasing or buying mineral rights or royalties. And Mr. Representative Oakey had also accused several landmen of predatory practices. His center, again, is in the district. His district's right in the center of all the activity up there in Carroll County. But you can get a feel for what we're dealing with here with the quote that was attributed to Representative Oakey at the bottom there. Again, us unscrupulous landmen out there, you know, stealing mineral rights away from poor old widow women and all that good stuff. And those charming, nice young people showing up at their house. But in Ohio, again, it is a little bit of a different situation. It's more of a disclosure forms issue, not so much unauthorized practice of law, but what do we need to disclose when we're talking to folks about negotiating a transaction, a lease or an easement, or a perpetual conveyance by minerals or royalties. There was another act that came through which we don't have referenced here. It was failed in committee as well. But there was a push to try to get landmen working under the Board of Realtors and working as real estate agents, or to be classified as a real estate agent in Ohio. And that ultimately failed a couple of years ago as well. But then there was also a case in U.S. District Court that was filed 2013, Wellington Resources Group, LLC versus Beck Energy Corp. And this case had a lot of twists and turns, but it touched on several pertinent issues. Not so much unauthorized practice of law, but what is a broker or a landman? What is their status and capacity when they're conducting some of these transactions? And with that, I'm going to hand it over to George to give you the specifics of the Wellington Resource case.
All right, well, there you, I think, had time to see the facts of this case, but let's turn to the next page. All right, here we go. Talking about the arguments that were made, you know, in the court. Oil and gas leases are included within the meaning of real estate to the person that sells as real estate broker. Number 3, real estate broker must be licensed. And then 4, no right of action can accrue and no compensation can be collected by real estate brokers who are unlicensed. All right, and then you'll see that the court rejected that argument, considered even the earliest oil and gas leases in Ohio, and concluded that Ohio courts consistently have treated oil and gas leases as different from interest in real property. There, because oil and gas leases are not interest in real property, a person negotiating the sale of same need not be licensed real estate broker in the state of Ohio. And it goes on to about, in further support of that conclusion, broker need not be licensed real estate broker. And it also addressed that legislation which would require the chief of the Ohio Division of Oil and Gas Resources Management authority to regulate land professionals requiring registration with the division. And so this, though it wasn't the unauthorized practice of law, it delves into who is a real estate broker, what is an oil and gas lease, and the potential to have land professionals regulated by the department, which did not successfully pass the state.
And there were some other interesting issues. I'd encourage you to look at this case, and George and I can provide you information on that if you would like. But among many of us in this room, I think we knew some of the folks that were parties to this litigation, and it was pretty interesting in a broker's standpoint about the nuances of that broker's fee and how it was broached. And ultimately, Wellington did win the case and received some monetary awards, I think, on appeal, after it was appealed.
All right. And how to spot a future lawyer.
I think he's trying to mitigate risk there, but I'm not really sure.
All you need is a moat. And last but not least, about Kentucky, countrywide home loans versus Kentucky Bar Association. Term closing is simply pointing to a signature lines. If that's what it is on pre-printed, pre-filed forms, it does not address preparation of legal documents, or leases by lay people. Then you have the Kentucky Supreme Court opinion, 1976, reaffirming that mortgages must be prepared by licensed attorneys. Since it could be easily translated to leasing, is what my perspective was. Filling in blanks without review by an attorney of the final product prior to presenting the documents for signature, in my opinion, constitutes the unauthorized practice of law.
And although I don't recommend it, how many landmen in the room have ever been at the kitchen table getting a lease signed that wasn't pre-filled and so-called pre-vetted even? And you may have the source of title and you may have the adjoinders, but they're willing to sign that lease and you're sitting there trying to furiously fill in the blanks, and that could be considered unauthorized practice of law by this decision. But it's a practical thing that we do on a fairly regular basis. And speaking a little bit to the UPL national issues, AAPL Nationals always stand on front of this. Again, they consider the unauthorized practice of law and the independent contractor status and misclassification of workers as two of the most pressing issues facing landmen in the country today. And so they stay on top of this. They're constantly tracking all the activity across the country. Again, in the more mature basins and the larger oil and gas play areas of the country, it's developed a lot more. So they've got a background to work with. Each state and each jurisdiction has its own little twists and turns and considerations to factor in. But they've got a rapid response team actually that's on site. As soon as they hear something, they're sending them out to the state legislatures. Texas, it's a perennial argument down there about being registered with the Texas Railroad Commission, landmen, similar to the Ohio real estate broker issues that they were trying to pass. New Mexico, Colorado were real similar to what's going on in Texas. Wyoming and Ohio have some different issues. Again, they're more focused towards our landmen real estate brokers or somehow in the real estate realty business. West Virginia, again, you've got the broad reaches that they're trying to do over there with the McMahon case and the advisory opinions. The legislature, I'm sure, will be looking at another bill in front of them next year when they come back, considering some sort of registration or kind of restrictions on landmen. As far as we know, currently only North Carolina requires any kind of registration for landmen. Fortunately, there's not a lot of oil and gas activity in North Carolina. There is, however, a lot of right-of-way and surface use agreement type activity. I do know a few landmen that have worked that area and have had to register with the state, and it's a perfunctory fee, like $100, I think. You go register with them, and you have to maintain that through the years that you're working in the state. But essentially, the argument generally boils down to the oil and gas industry's historic reliance on voluntary certification and internal policing amongst their folks. And again, code of ethics, monitoring, and enforcement as practiced by AAPL, AAPL has been very, very successful with their lobbying groups to keep making that point that, hey, not all landmen out there are AAPL members, but the ones that are AAPL members, we're on front of this. We agree we need to keep a code of ethics in place, have some sort of censor and violations process in place. So far, that's worked well for landmen. We'll see how that changes in the future. But we could have, we could be seeing some sort of mandatory licensing ultimately. In some of the more liberal states or more states where more egregious acts have been committed against some landowners. And there have been some pretty grievous acts, of folks out there trying to lease properties and promising the world and, just not coming down and doing what they're saying they were doing or were supposed to do. So we got a couple of scenarios, and we're going to conclude here in just a moment. We want to wrap it up, though. These are more focused towards a landman audience. So, as we ask these questions, kind of take that approach. But as you're asking your landmen to do certain things, keep some of these scenarios in mind. We're going to open it up for discussion if you want to have any input to some of these issues. Again, some of these issues are very gray, which I've always found the attorneys love gray issues. Gray issues can be argued and debated out of court and in court. Black and white is, much more black and white, but a lot of these issues are very, very gray. So let's consider this scenario. As a landman, your new client, Feistbuck Promotions LLC, calls you from Texas. They want you to provide all realm of land services, leasing, due diligence, right-of-way, everything they need for a new project that they're undertaking. But it involves an old field in an outlier county that is not home to a lot of current activity, way outside of Lawrence and Johnson County, Kentucky, let's say. After some initial takeoff title work and some curative leasing's done, the client will call you back and ask if you can make an ownership report look a lot more like this title opinion that he has. But an attorney friend of his in Texas, who by the way charges $650 an hour, you don't want to use that guy, but can you make your ownership report look a little more like this title opinion in format and spacing and such? So he's got that, and he asks, well, can you also tone down some of your potential ownership issues or your curative requirements, your comments and requirements that you're making? We don't want to frighten away my investors by your ownership reports. So what should you do? And I think that's pretty clear cut and blatant. This is actually based on an actual experience that I've had in years past. Change the names to protect the innocent or the not so innocent, as the case may be, of course, but there's always a case of what do I need to do for certain people? What can I present to my investors that really gets them over the finish line with us? But as landmen, of course, we can't certify title. We can't even appear to certify title. Our ownership reports are ownership reports, but mine has 1 million disclaimers, which we'll look at a couple of those in a moment. But what would you do if you were asked to do that, Wes? If Mr. Feistbuck calls you up and says, hey, can you help me out here?
Obviously, I'm just going to report the facts. That's all you can do.
That's all you can do. And that's what I did in this case, too, when, again, it was based on real-world experience. Surprisingly, not surprisingly, this fellow ended up in a litigation a few years later. And, of course, I'd done the right thing, so I wasn't sucked into that, fortunately. Which leads us to scenario 2.
Can you back up?
Hold it up. An old established client of George's, actually, Smoky Mountain Oil and Gas, or SMOG, calls you up and asks if you can prepare some new updated lease forms and ratification instruments. His old 2-page Producers 88 forms just won't cut it these days because all these landowners have cousins up in Ohio or somewhere who've educated them now and brought them up to speed, in his opinion. He doesn't want to use the downtown attorneys that he keeps on retainer for litigation and regulatory, and he doesn't want you to reach out to them either to keep billable hours down. So what should you do in that respect? George, what would you do? Well, you're an attorney. I shouldn't even ask you.
Just one comment I was going to make about this is that actually I had a client, choosing names is an art form, and it was Golden Fleece LLC or Golden Fleece Petroleum, and I thought, golly, why would you ever have something like that? And actually we looked at different names we were trying to come up with when I was at Equitable, and this was one of the names, Smoky Mountain Oil and Gas, and then the acronym is SMOG. So that got deleted real quick. But
it's like Dewey, Cheatham, and Howe, attorneys at law, right? But of course, in this case, exactly because they probably do have relatives in other states, you want to make sure that your lease forms are updated. You want an attorney to review those with all the different, post-production deduct issues and net proceeds issues and all the many things that are going on out there today. The old Producers 88 leases are just a thing of the past. We should put them in the museums and not even carry them around anymore. It's a hard habit for a lot of us to break, especially folks that's been at this for more than 5 or 6 years. I've had an old mentor and an old client that he used to tell me, if you put a lease on more than 2 legal size pages front and back, you'll never get it signed. It's going to go somewhere for interpretation. Of course, the point size was about 6 point. If you put that out on normal spacing and normal font size, it had been an 8 or 9 page lease, but that was his approach. And I think a lot of us probably still have that approach. Keep it like we've always had it and it'll be okay, but things are different these days. I mean, things have just changed drastically. And it's much more than just your term and your royalty and your implied covenants and things. But you should have your attorneys update your lease forms, not your landmen.
And there are some states like Tennessee that require certain size type on leases. Because I think, I'm trying to think who it was 30 years ago, used their leases and then they had to go back and release with the correct form.
Yeah, you don't want to invalidate your leases. In Ohio, you have to have a 2-inch margin at the top so they can have all the various county offices do their stamps and approve. So, which takes us to scenario number 3. A landowner you've already leased and you're now negotiating a surface use agreement with for your client, Big Time Texas Oil Corp., has asked you for some legal advice based on your past experiences, not for himself, but for his neighbor. The neighbor wants to lease 200 acres next door to a competitor, late to the party hydrocarbons. So you know that your client wants to include at least a portion of the neighbor's farm in the unit that will ultimately be formed from a well that will be drilled upon your landowner's lease that you've already leased. And will consider forced pooling, your client will consider forced pooling them if a lease cannot be obtained at reasonable rates from the neighbor with the 200 acres. So what should you do in that situation if you're a landman? Anybody?
George's number.
Give them George Mason's number. Well, obviously, the first thing you got to do is you can't breach any confidentiality. If you know that your client is planning on drilling a well there, you're working on a surface use agreement with them, so there's some indication that something's going to happen there. You may even have told your lessor that you're going to drill a well there. But the confidential fact that comes in here, if you know that if they can't lease the neighbor, they could possibly force pool them. You can't give legal advice anyway, based on your experiences or anything else. So that would be one just to run away from as fast as you can. Change the subject. Hey, did you see that wolf running over there or something? Just change the subject and move on. You can't give legal advice in that regard. Don't breach your confidentiality ever with your clients. Which brings us to the final one, number 4. That old reliable client, Smoky Mountain Oil and Gas, SMOG, calls you back and asks for your interpretation, quote unquote, of the intent of the parties to an old vague conveyance from 1919 that was noted as an exception and a curative requirement previously in the chain of title for a 30-year-old title opinion that he's dusted off. He now plans on drilling a new $900,000 or so AFE horizontal well under this old lease for which he had the title opinion 30 years ago done. That lease is now being held by Vertical Production. And he makes it clear to the landman that he thinks that the exception was just malarkey or BS in the very first place, and he wants to proceed without curative or any kind of supplemental title opinion. He wants to know what your interpretation of that is, and if you concur with him. What should you do in that case as a landman? And this is also based on first-hand experience too. Recent first-hand experience.
Get your attorney, get him to update the title opinion, and I'd even go back, and see if that 30-year-old title opinion, if there were any gaps, because that's what I found, when I was a, company oil and gas, attorney, is you have these old leases, old title opinions, and some of them, I swear,
some are better than others.
It came like a mimeograph machine, fill in the blanks,
Factory output in some cases. Well, in this case, obviously he needs a new supplemental update opinion to that old opinion to proceed. this is probably a little better scenario, and again, it is based on actual occurrence. A lot of times, as many of you folks in this room know too, for shallow production and in the years past, title opinions may or may not have been sought. A lot of folks have drilled on abstracts over the years. Going forward today, folks, don't drill on abstracts anymore. I mean, it's just never a good idea, especially if you have investors. A lot of your investors are going to require a title opinion of some sort as well. But, you know, there's still a lot of that mentality in some of the folks out there across Appalachian Basin completely. You know, well, we just drill on abstracts. We save costs. We carry that cost straight through. It's right off the AFE. It saves everybody money. Never a good idea these days. And finally, just some recommendations for landmen and oil and gas operators that was working with landmen. If anybody's ever worked with me, and several of you have over the years, you're going to find that I've got a full 1-page or more disclaimer on everything that we send out, ownership reports, run sheets, abstracts, anything like that. Basically saying that I am not an attorney, I'm not holding myself out as an attorney, subject to any errors or omissions found in the courthouse, of which there's many in some of these courthouses. You just can't assume that liability as a reporter of what's in those books. So we've got pretty extensive due diligence or disclaimers in any of our due diligence reports or ownerships. But if you remember, if you go back to that McMahon case, it was or the advisory opinion that was based on the McMahon case, one of the points that the state bar in West Virginia had made was that they didn't feel that disclaimers did anything but encourage unauthorized practice of law. It's okay as long as you have a 1-page disclaimer. It's essentially what they were saying. Again, I don't necessarily concur with that, and the AAPL doesn't either. They encourage us all to put, you know, disclaimers on there, seek your attorney's advice. I don't put George's phone number on any of my disclaimers anymore, but when they call me, that's usually who I refer them to.
Well, something else too, I did several hundred title opinions for a company in West Virginia that I never went to the courthouse. They never wanted me to go to the courthouse. They got the documents, you know, made an arrangement with the court clerk to copy all the documents, get an update. They'd send them to their, you know, office, and then at first it was outside, then it became inside, and I think they farmed some of that out. But what it was one of the disclaimers, obviously, was that, you know, this is, you know, I'm following, and it really wasn't an abstract. My concept of an abstract is a narrative of what the title is, whereas what I received was really an index, you know, of the latest to the earliest documents. And of course, I was dependent on that, and I put in one of the requirements was that I had not done an independent courthouse search in the particular county of West Virginia in rendering this title opinion. I relied completely on the abstract and the records that I received from the land department of that company. And I mean, that's it. You know, I could only give the opinion on what I received. So if it wasn't there, and there were times where we could tell that there was something missing, we'd contact the land department. They'd get a landman out there, see if that document was there, if it was missing internally, you know, to give them a heads up.
It's always good to trust but verify whenever you can. It's hard to do that in some of these cases with the online databases that a lot of folks are using these days across multiple states and basins. Another point, just, you know, always err on the side of caution. If you're an operator or a landman, stay in contact with your company's in-house counsel if they have it, or if they have somebody downtown. Stay in touch with the attorneys. Encourage that communication between your legal and your land folks. As a landman, you know, reach out if you have to and make that call. A lot of attorneys are very busy folks, and it's hard to get some time with them on the phone or in face, but it can save you some grief and trouble and treasure later. So encourage that communication between land and legal. And again, I would encourage everybody, the landmen and the operators, to stay plugged in with AAPL and what they're doing on unauthorized practice of law issues. You know, independent contractor issues are something that you folks contend with a lot too. And, you know, what is a 1099 employee or a service contractor, not an employee? That's something that, you know, it's been a few brokers that I know and some other folks and some oil and gas operators that I know. The service companies are getting hit with that as well. So there's a lot of audits going on out there. Department of Labor, workers' compensation departments for state tax revenues. There's 5 or 6 different agencies that can come at you for those 1099 issues, and you want to just err on the side of caution. And again, unauthorized practice of law issues is essentially an ethical issue. So if you do something and it don't feel right or it don't taste right or it just leaves a bad taste in your mouth, it's probably wrong. So trust your gut, keep your conscience open and sleep well at night.
And finally?
And we got the old one here.
Yeah, I got Rogersville Shale. Is it the unauthorized practice of painting if you paint a white mustache on an attorney? And the last one. And my son said, "Dad, are you going to use this again?" I said, "Yeah, because I don't have anything else to fill in for it." So the only thing is still 19. About a week, he'll be 20.
Yep. And we'll leave you with this little snippet here, which we keep on our refrigerator in my office, and it's always when the client calls and says, "How much longer is that title opinion going to take?" We send them this cartoon. Kind of explains it a little bit.
And we'll open it to any type of questions.
George, just a question. Someone asked me a couple of weeks ago, is Kentucky, everyone's got a new lease form that they come up now. So is there a font size for Kentucky that the font has to be, does it have to be 10, 8? Is there a restriction in Kentucky?
I'm not sure. I have not seen that issue. I know it's come up in Tennessee like 20, 30 years ago. But I'll look that up, because obviously I need to know.
Right, correct, because I had actually, as a landman, I come down to Tennessee that brought that to our attention, so I had never heard of that in Kentucky, so.
Oh, because he was in Tennessee.
Yes.
All right.
Yeah, that might be a carryover from his time in Tennessee, maybe.
Yeah.
Okay,
Not that I know, but I'm going to look for it.
okay.
Let me throw a question out to everybody before we wrap up. Have any of you all had any issues with unauthorized practice of law with any of your land people? Have you had any concerns or anything brought to your attention in the recent past? I don't really know that it's a problem here in Kentucky, but again, we know it is next door in a couple of states, and as things develop, we might be able to start seeing a little more of this. So, yes, Mike?
If your company prepares the lease document, and then for, of course, recording, you have to sign as the preparer. If you sign that, not being an attorney, are you then opening yourself up for practicing law?
I'll tell you what, I've been thinking about that for some time before this. I think you have to be real careful, but I've seen so many people, in fact, what I've prepared, then they've taken the prepared by block of mine off, and then put theirs on and signed it and recorded it. And so I think it's a gray area, in Kentucky. I think in Virginia, you've got to have an attorney sign it, I think it is, and especially if it's someone outside, of the state of Virginia.
And I would jump in and say, personally, Mike, I know we all do that. My name's on hundreds of documents across the Appalachian Basin. But for the last 3 or 4 years, though, I have been putting on there prepared by, on behalf of lessee, or whoever I'm working for. Usually it's the lessee. And under, there's some intent that was under their supervision of some sort. So if you get into the self-prepared type arguments or such.
Even those that I have a prepared by, I'll have, in many cases, prepared by without a title search. If it has to do anything with, a deed, a lease, or what have you, where there was some expectation that I was supposed to, verify that they had clear title. So I put that in for my own protection.
Any other questions? The forms for the continuing education credit, AAPL continuing education credit, are available at the front desk, and you may pick them up there. And with that, we conclude our program. Thanks everybody for sticking around, staying. Thanks, George. Thank you.